Good evening, everyone. Thank you to LiveLaw for offering us a forum for this extremely important and timely conversation. And thank you to everyone who has joined us this evening. Today's conversation concerns the recent spate of FIRs against reporters and journalists across the country, ranging from Srinagar in Kashmir to Solan, Shimla, other places in Himachal, to Ahmedabad in Gujarat, Varanasi, Coimbatore, even Mumbai, Delhi, and the Andaman Islands. And these FIRs have been in respect of a range of offenses, both cognizable and non-cognizable. So to name a few of the cognizable offenses, they've been sedition, unlawful activity under the UAPA, promoting enmity between religious groups, and the non-cognizable, of course, have been Section 188, which is the disobedience of orders of public servants and obstructing public officers under the Disaster Management Act. So these FIRs have come at a time when journalists and media houses have also been under other kinds of legal action. So they've faced show cause notices, interrogations from state police in some states. Some channels have faced bans for a couple of days. And they also face extra legal intimidation at this time, such as death threats from private parties. So what is at stake, needless to say, is not only the lives and liberties of the press community who are doing an extremely crucial job for the running of our republic at this time, but also the constitutionally guaranteed freedoms such as the freedom of press and the right to information of the Indian public. So to have this important conversation with us today, we have a very esteemed panel, and I'd like to welcome them to this conversation. The panel comprises Ms. Seema Chishti. I apologize. Ms. Chishti is a senior journalist, and she's currently serving as the deputy editor at the Indian Express. Dr. Colin Gonsalves is also here. He is a senior advocate at the Supreme Court of India and the founder of the Human Rights Law Network. And Justice Madan Lokur is also with us today. He is a former judge of the Indian Supreme Court, and he currently serves on the Supreme Court of Fiji. Before we start, just a few housekeeping points. The format of the panel will be that I will first invite 2 rounds of comments from each speaker. This round of comments will take about 60 minutes, following which I will open the floor for questions to the audience for the last 15 minutes. I request everyone who is watching and streaming to place their questions in the Q&A box in the Zoom interface. My first question is to Ms. Chishti. I'd like to invite your comments, ma'am, on the kinds of constraints and setbacks that journalists are facing today, because we understand from at least news reports that they've come under pressure from a lot of quarters, not just in terms of FIRs against them, but also restrictions on their movement, lack of support in obtaining press cards if you're a freelance journalist, meeting legal expenses when you're dragged into a criminal trial. And of course, there are larger structural issues in media ownership and advertising and such like. So would you share a bit about these constraints facing particularly local reporters, but also national reporters, and more so in the time of this pandemic, when all of these issues appear to be additionally aggravated to the lay public?
Right. I may have lost you. Malvika, can you hear me?
Yes, ma'am, I can hear you.
Hello.
Ma'am, are you still on the call?
Hi.
Ma'am, can you hear us?
I can hear you, yes.
Okay. Should I repeat my question, ma'am?
Your video is freezing, but I can hear you.
Okay.
You want to just quick, yeah. You want me to talk about the constraints that journalists function under currently?
Yes, please.
Right?
Yes, please.
Okay. Much for organizing this LiveLaw and Malvika, for looking at a very serious issue in such a structured way. And I hope something good will come out of it at the end of our time. Basically, journalists are operating currently in a very grim scenario. The World Press Freedom Index, India stands at 142 out of 180 countries. 180 is North Korea. We've fallen 2 ranks since last year. The Committee for the Protection of Journalists says that 23 Indian journalists have died, have been murdered over 10 years. And over the past 6 years, 14 have been killed. And another chilling thing which has contributed to the nip in the air has been other things not directly connected with journalists, but events in Kashmir in the way they've unfolded. A report says that since August 2019, there were more than 600 habeas corpus petitions, of which 99% have still to be addressed. So the overall context for missing people, for speaking, for journalism is quite grim. But I want to just talk about 4 broad areas, I think, in which the maximum constraints by journalists are felt. One is, of course, is the government approach to journalists. You mentioned about how it's difficult for freelance journalists to get cards for legal fees. All that, of course, stays, but that's been a problem with freelance journalists anyway for a long time. But, let me draw your attention, everyone's attention, to the most privileged journalists, who are the Press Information Bureau, the PIB card holders. They are security vetted by the Ministry of Home Affairs. They go through a screening process, and they are expected to have certain rights and certain claims on the times of the government. They are entitled to replies. There's been a kind of a quashing of that. You had the Finance Ministry before the budget kind of putting restraints on their entry into the Finance Ministry, on just access to information. So it's almost like it's a bad thing. In a larger thing also, I'm sure that it really helps the ruling establishment to directly communicate with people because they do it through social media. The Prime Minister so far has not given a press conference. He's just finished an address, which would be very effective. But what it does is it actually shoots the intermediary. So the whole role of the media as a mediator between government, analyzing policy, evaluating policy, and being taken seriously is not happening. So, of course, you don't have a complete Trumpian situation or of Boris Johnson where his government is going after journalists by tweeting aggressively against reports. You don't have this fake news thingy. But PIB, for instance, has started a fact check. That doesn't fact check false news or hate news. It actually checks on anything which is holding the government accountable. Now, which is okay, the government is entitled to have its say, and it should comment on important stories, but it's labeled fact news. So basically, this kind of an environment where senior ministers have gone on record calling journalists prostitutes. The media was referred to as Bazaru by the highest in the ruling party. That has been a problem. So the general government approach to journalists is not one of accepting them as honest brokers or of commenting on stories or of having a role in a functioning democracy. They are pretty much sidelined, or at least a section of journalists who are critical and who say things which may not be palatable are banded and called names. So that is not helping the thing. So you must understand that journalists operate in this environment. The second thing, of course, is media itself. I think media, because of technological reasons, because of digital media, the coming of age of social media, are anyway facing challenging times. It's a time of great challenge for the whole business model of the newspaper, which has pretty much collapsed without government ads, etc. So that is a hindrance in the way media is kind of seen, So that there is, because of newsprint costs, policies, you're expected to have a particular, it is kind of accountable or pinning them down or taking them to task. And then you have what is called the general public opinion. I can imagine, I'm too young to have known that, but I hear about when the emergency was declared, you could, Jansatta editors or newspaper editors, if gagged, would get public support. You could get the marching public out on the streets if journalism was curtailed. I don't see that kind of support for journalists now, which may have to do with perhaps a lot of fake news coming by way of journalists. And you have the picturization in popular culture, starting actually all the way from Damini, where journalists are pretty much shown as the vultures. They're not really welcome. They're making money. They do paid news. That's the kind of stereotype that has actually come out. So the public opinion is exactly not on the side of journalists being given a tough time. We're almost seen as very close to the establishment. So there's an element of glee when a journalist is kind of put in place, or somebody is abusive, or trollers come after you. And number 4 is very important, and I think of direct relevance to the webinar today, is institutional support. Journalists, just carry the pen, and it may be mightier than the sword. organizations outside, particularly the judiciary, needs to kind of have to do is quite missing. And, we'll go into this later when we talk about what kind of institutional support we can expect. But the kind of Supreme Court you had, I mean, I think it was exactly 70 years ago that you had the Ramesh Thapar case of Crossroads, when the court comes out and speaks highly about the right of journalists to inform and to make their case. So journalism has always also been a very tenuous kind of an extension of Article 19. We're not explicitly guaranteed the right to freedom to report, as it were. It's derived from that. And the word coming from courts is not exactly very supportive. There was a time when there was this whole business of, for the fairness of a trial, let's gag its reporting. We came very close to the Supreme Court having guidelines on what can and cannot be reported. Of late, courts also coming out and talking about social media seems to also be aimed at journalists as well. This kind of, that it is wrong to comment. It is some sort of blasphemy almost that is happening. So I think the environment on all these accounts, in accounts of the media itself, in account of public opinion, on account of institutional support, has been waning. And I conclude this bit by just saying that the really tricky bit is that till I think Gauri Lankesh, and you had the tragic murder, etc., it was actually, and you had whistleblowers and journalists being killed and shot dead. That was actually going after journalists as per unlawful means. What's really dangerous is this new trend of using the law to actually go after journalists. So you have the most recent Supriya Sharma case in the Supreme Court of actually using the SC Act. So who in their right minds can come out and say that the lady who has petitioned does not have her rights? Or you have sedition being used, or you have the IT Act being used. So I think that's a much more clever and a devious way to get around journalists and give them a really hard time, which in a sense is also more, insidious than, just shooting them down. That was, you were doing an unlawful thing. Now law is being marshaled in ways to go after journalists. So I think it's a very challenging time and challenging circumstances in which they're. Do you want me to quickly talk about the COVID thing briefly, Malvika?
Sure.
How things have changed during COVID? Okay.
Sure.
So, and COVID, of course, So COVID, of course, brought another kind of set of problems completely for journalists. There was clearly the health crisis. Journalists were, they had the same problems getting PPE, getting guidance, getting proper training and equipment to go out and report, particularly photographers, going and asking questions. They were after health workers and government servants helping. They were almost, in the front line of the disease without any protection. Number two is their own personal economics was threatened at a time of the pandemic. We've had layoffs. We've had we have several magazines shutting down. We've had salary cuts across the board, in newspapers and magazines. That clearly, left journalists with very little time to figure out about what was happening, and huge things have happened. What was happening. And number three, of course, was then the police. The police directly, the Danda directly at play. So the Epidemics Act, whether it is Section 188, about defying a public authority, I think everything was pulled up. And there was a report put out by the RRAG, the Rights and Risk Analysis Group, which says 55 journalists were picked up, targeted, jailed, in just the post-COVID scenario. So that has completely been kind of from the frying pan into the fire for journalists.
Thank you, ma'am. Dr. Gonzalez, I'd like to lift off from where Ms. Chishti left us. Particularly, of course, there's a range of offenses that are registered in FIRs against journalists. So fake news has been registered under Section 5051 of the IPC. But I want to invite your comments particularly on three broad sets of offenses that we see repeatedly in FIRs. The first is the way in which sedition continues to be used against journalists, an offense in which, as we all know, there can be a great degree of subjectivity in even whether the offense is made out, given Kedarnath Singh. The second offense is criminal defamation. And perhaps, so if you would also like to comment on the other ways in which state-sponsored repression of journalists has taken place, even if not directly through FIRs, but other legal machinery that's been deployed against them.
Thank you, Malvika. I sort of agree with what Seema said a few minutes ago, that sometimes the use of the law can have as much a chilling effect on journalists and the practice of their profession as the danda or some physical attack on journalists. I have in my own practice come across at least 25 cases of journalists who have been threatened with sedition. So FIRs have been registered against them. And if they don't toe the line, then the police go ahead and register charge. So sedition is very widely used and is not carefully monitored. And I think if journalists across the country monitor the number of journalists who've got sedition charges against them, it could possibly reach 100 at least in the country. And particularly in rural areas where journalists have little access to good lawyers and so on, you'd find sedition cases, or even if the case doesn't culminate in a charge sheet, FIRs are lodged against journalists. Now, sedition is a very specific charge. 124A is the use of words, let us say, or signs, right, to bring into hatred or contempt or excite disaffection against the government, against the state, right? And it's such an obnoxious provision because one really doesn't know what this means. For example, it's perfectly valid or it's perfectly legitimate if I were to say, I hate this government. I could well say, I'm in contempt of this government. I hate this. I could say I hate so-and-so, minister and so on. It's all right. It's freedom of speech and expression. And it's the old English law being used today in India. Namely, if you say things that people in power find obnoxious or reprehensible, that would be sedition. That's not sedition at all. And right across the world, because this section is so ambiguous and capable of stifling free speech, it's been repealed right across the world. Now we've tried, Pankaj Bhutalia, for example, we tried heroically twice in the Supreme Court to try and get the section itself declared unconstitutional. Because as long as you have the section on the statute book, courts told us, well, there's a 5-judge bench decision. They've dealt with sedition. They watered it down. They watered it down, yes. But if you look at Kedarnath's case, it's very, very poorly written, very ambiguous. And it should have said that you can't be punished for mere words. You can't be punished if you're a cartoonist. Can you imagine sedition cases in cases of photojournalists? People taking photographs, in the COVID period came under sedition for taking a photograph, So the basic principle is, and this was subsequently clarified in 2 judgments of the Supreme Court, one in the case of Kashmir and the other in the case of Punjab, absent an overt act of violence, which threatens the security of the state, absent that, no matter how harsh the words are, how strong the words are, how offensive it might be to a particular person, it is not sedition. It may be some other minor offense, but absent an overt act. And the Punjab case is very important. He came out on the street and said, I want Khalistan. I don't want India anymore. I want to break away and have Khalistan. He was caught in sedition. He was convicted under the sedition charge. But when it came to the Supreme Court asked, after this gentleman said he wanted Khalistan, the use of force, what happened? And the answer of the public prosecutor was, nothing happened, sir. He didn't do anything. And a case from Kashmir which said Azadi, we must get guns and get ourselves free. We need Azadi. And he advocated the use of guns. Again, the Supreme Court said, did he actually use a gun? Did he actually throw a bomb? And the answer was no. And he was acquitted of the charge of sedition. So sedition remains to be one of the main problems for journalists. And I think it might be a good idea for a collective of journalists to go to the Supreme Court again, say that after Kedarnath's case, Kedarnath has not had a breaking effect on the misuse of this section. And Kedarnath was 35 years ago. And now we want this court to look at it and declare it unconstitutional, so it's never used again. You remember Kishore Chandra's case, Manipur, who got so angry with his chief minister over what he said, something very demeaning about people and so on. And he used the word FO, and the chief minister of Manipur was so offended that a journalist could tell him to FO, and he filed a sedition case against him. And can you imagine, he remained in jail for a little over a year. And it took a lot of pressing for the case to be heard in the High Court of Manipur, for ultimately to be released on bail. The case is still pending. So Pankaj has tried very hard, the filmmaker has tried very hard, and I think we should try once again to get the section repealed. Now, I want to tell you a few things about how extensively it's used. You remember the cartoonist case who made a cartoon, I think, of the Prophet. You know, it was not sedition. I mean, it might be offensive to some, but it wasn't sedition. But he was taken. And I've seen in Uttarakhand, large number of trade union activists have been taken in sedition merely for putting up posters and using the slogan "Inqilab Zindabad," mobilization karna zaruri hai. Again, they were taken in sedition. Then we can move on. There is, by the way, a very nice speech made by Justice Deepak Gupta while he was the presiding judge of the Supreme Court. And that's on the internet. You must get that, because that's a beautiful exposition of how sedition law is being misused and what needs to be done in the future. Criminal defamation is another huge problem for journalists. And I've seen it used particularly against those writing on the environment. When they cover stories and they go to areas and they look at pollution coming out of factories and they write on that, there are many very powerful corporations, and you can imagine there are one or two very powerful corporations from the state of Gujarat who have filed cases against Seema, Mustafa and others, saying that you've defamed us by writing this about. Now, it's a long haul to actually show that, you know, what you've said is correct, what you've said is accurate, what you've said is truthful. But in the meanwhile, the journalist goes through years and years of difficulty, running to the court, filing your affidavit, getting your lawyers, getting adjournments again and again and again. So criminal defamation is a serious problem. And we have an impediment in terms of a Supreme Court judgment which dealt with reputation vis-a-vis freedom of speech and expression. And unfortunately, the ultimate result that came out of that was, in my words, reputation trumps defamation. So a person's reputation is paramount, and freedom of speech and expression must bend to that. And so the challenge to criminal defamation law, that it's unconstitutional, has sort of waned for the time being. But there are other benches of the Supreme Court that have looked at criminal defamation cases against journalists and have very quickly granted stay on those proceedings to look at the whole issue of criminal defamation law and its application to journalists. Now, the last thing that I want to talk about very briefly is the most merciless thing, which is the killing of journalists. And we have documented a large number of killings that have taken place over the last 20 years. Gauri Lankesh's case, again, was a very prominent case because she was a very prominent person. But the killing of Gauri Lankesh actually points in the direction of physical violence on an extended scale, again and again happening in the country, happening in all the states, where they shoot a journalist if they think a journalist is writing against them. Gauri Lankesh got a lot of publicity because she was such a popular and prominent person. But I am appearing in Jagendra's case, where he wrote about a minister and the sand mafia. And it was such a tragic case. They went into his house, they broke down his door, they carried petrol with them, they poured the petrol on his body, and they burnt him. He then came out of his house and he was taken to a magistrate, where it is caught on video that he recorded his testimony saying, "I was burnt by the goons of this minister." He was then taken again to another minister, and again on video, his dying declaration was taken where he identified the minister as his assailant. And then it went to the court, and ultimately the Director General Police had the audacity to say that he committed suicide in the face of these two videograph testimonies. And now his case is in sort of some kind of limbo. It's gone again to the High Court to try and revive the case. But violence against journalists is an issue on which we need to put a lot of work. With that, I'd like to stop.
Hi, Malvika ma'am. I think your microphone is on mute. Yes.
Okay. Yeah, am I audible now?
Yes, ma'am, you can proceed. Yeah.
Justice Lokur, I also want to fold in some questions that we've already got from the audience in my question for you. I wanted to invite your thoughts on what it is that criminal courts and constitutional courts can do in response to these kinds of FIRs, whether in the FIR stage or in the investigation stage or even at the trial stage. And I ask this particularly in the context, sir, of the fact that there is great variance in what becomes condoned in the name of press freedom. So some news channels in the last few months after COVID, I think, were banned. No, sorry, this was during the Delhi riots. They were banned for a couple of days, while others continue to just get warnings or a mere direction to take down their content from their website, even though the broadcast has been allowed. And then when these challenges come up before constitutional courts, by virtue of just institutional design, they come up before different benches because our courts don't sit en banc or in a full bench. And then we see that these FIRs, although with similar charges and similar allegations, are given different kinds of redress by different benches. So, sir, my question to you is, what is it, realistically speaking, that our court system can be doing as a matter of press freedom for journalists who have FIRs against them?
Yeah, thank you, Malvika, and thank you to LiveLaw for organizing this discussion. You know, I think by and large, you know, if you look at the criminal law, the criminal justice system, you know, not segregating journalists from other persons, there are a few things that need to be done. You know, for example, I think it's a given that investigations must be fair, right? So whether it's a journalist or whether it's a common citizen, the investigation itself must be fair. But what has happened, you know, in the recent past is that all kinds of problems have started coming in this investigation. For example, during the course of an investigation in Hyderabad, in the case of a rape victim, an allegation was made that this person tried to run away, right? So there were 10 policemen. They said we had no option but to shoot him. So they shot him and killed him. That's not fair investigation, right? Now, that could happen even to a journalist. You know, in this case, it happened to a person who was accused of rape. But supposing a journalist was to file a story or to, you know, look into something, go to Delhi riots or, you know, some other place where there's a riot going on, some activity going on, the person could be picked up, you know, and then during investigations eliminated, right? Then you have, well, it's a somewhat pre-investigation stage. What happened in Tamil Nadu recently, right? The father and son were tortured, they died. And what did the police say? The police say, well, they had a heart condition. Today, it has come out that, you know, some of the videos of that particular date seem to have been deleted, you know, so evidence has been destroyed. So, you know, with these kind of things happening, it's very difficult to, you know, to trust the police and say that, well, there's going to be a fair investigation. So when a complaint is filed against a journalist, this fear is bound to be there in the mind of the journalist that, am I going to get a fair investigation or not? And if the investigation is not going to be fair, then I've had it. You know, I'm going to be inside, locked up for a very long time. And Seema had mentioned about this risk and what is it called? Analysis group. Some journalists have been arrested. Okay, so I'm not saying that the investigation in those cases, was not done properly, but this is one of the problems that a journalist can face. That is one. The second is, complete misinterpretation of the law. Colin has given some examples, where clearly sedition is not made out, but a person is booked for sedition, right? It could happen to a journalist, and it has happened to journalists, where there's no question of any sedition, but the police say, oh, according to us, our investigations show that there is sedition, and so therefore, we book that person. I came across recently a very, strange case from the Philippines, where one journalist had written a story, right, on the website. This was way back in 2012, right? And there was some law that was passed much later, not years later, but months later. And there was perhaps some typo or something in that, in the write-up by the journalist. So that typo was corrected. And the police said, this is a republication of that article. And if there's a republication of that article, then it violates the law, which has now come into force. So this journalist was actually convicted, and the punishment, I think she gets about 6 years or something, or 7 years imprisonment. She's filed an appeal. She's out for the moment. But this is how laws can get misinterpreted, right? During the stage of investigation, and then on the basis of a misinterpreted law, the police will file a charge sheet, and then, the trial takes place and so on. That's one. The second thing is, what is the role of the court? So if a journalist, for example, is to be produced in court for the purposes of being arrested for carrying out investigations, the court, the magistrate, has to be very, very careful and to see that prima facie an offense is made out. There is some substance in the FIR, there is some substance in the complaint, and only then should the magistrate say that, all right, I'm going to take things forward. Now, in this recent case of Tamil Nadu, for example, it seems that the magistrate didn't even see the, the father and son, and said, all right, you police remand or judicial remand, whatever. It can't be like that, just because the prosecution says that according to me, sedition has been made out, the magistrate should not automatically say, all right, sedition has been made out, or there's an allegation of sedition, so put this person, in police custody or judicial custody. There has to be a clear application of mind. Now, you could have offenses, allegations made of violation of the Unlawful Activities Prevention Act. All right, very, very serious offense. We are talking about sedition. Unlawful Activities Prevention Act, also very serious offense. But just because it is Unlawful Activities Prevention Act doesn't mean that the magistrate should say, all right, unlawful activities, so therefore send this person to custody. It shouldn't be like that. Even there, for example, I will tell you in this, the case of Scheduled Caste and Scheduled Tribe Prevention of Atrocities Act, there is no provision for anticipatory bail. But the Supreme Court has said that prima facie, if no case is made out, the person should not be arrested and should be released on bail. Why can't that logic be applied to the Unlawful Activities Prevention Act? Supposing a very foolish sort of a case is filed against a person. A person is going on the street, going to the bank or going to an ATM to pick up some money, and some policeman comes and says, oh, he was going to pick up money from the ATM, and I have a feeling that he was going to use that money for a terrorist offense. So therefore, he's a terrorist, and therefore Unlawful Activities Prevention Act. It doesn't make sense at all. Now, can the magistrate say that, oh, Unlawful Activities Prevention Act, I'm going to put you inside? Prima facie, no case is made out. So really the judiciary also has to be on guard. The police, of course, they have to be on guard. They have to carry out fair investigations, but recent events have shown that there's a problem in that. The judiciary has to be on guard that, listen, the police is not exceeding its authority. They should not be doing things which they're not supposed to do, prepare a trumped-up case or something. Examine the FIR, examine the case diary, find out what is going on, and then, if necessary, allow them to proceed by, sending the person into police custody or into judicial remand. You had mentioned about, discrepancies in orders that are being passed by the courts. Now, most of these are interim orders. And this is a problem that has been going on since, ever since I began my practice in the 1970s. I know of so many cases in the 1980s, including one of the cases which I had done, where, in a series of matters, the Delhi High Court had given a particular interim order. In another case, they said, no, we're not going to give you an interim order. I had to go to the Supreme Court, and the Supreme Court said, listen, if you've given this interim order in 10 cases, it was not a criminal case. If you've given this interim order in 10 cases, why are you not giving it in the 11th case? Right? There was no judgment. But then subsequently, I think 1984 or 85 or something, the Supreme Court gave a judgment and said there has to be this consistency. If on a particular set of facts you give an interim order to one party, you should give it to the other party as well. Or if there is some reason why you're not giving it, put down those reasons and say that, well, this case is not similar to that case. So here, what has been happening is that these interim orders, some court feels that yes, we should stay the FIR. No reason given. Another court says, no, we should not stay the FIR. Investigation should go on. No reason given. Or very sketchy reason given. Now, in the case of a journalist, as an individual or any other person, how many people can afford to go to the Supreme Court? A case is filed against you in Tamil Nadu or filed against you in Gujarat or wherever. And the magistrate says, or the High Court says, no, you see, we don't see any reason to stay the FIR. Or we see no reason to, stop investigations. We can't go to the Supreme Court. So the judiciary has to be extra vigilant in these kind of cases and not just, go on the basis that, well, okay, the prosecution has said so, therefore it must be correct. That's not the law. Yeah. Thank you.
Thank you. I'm going to shift gears a little bit, having discussed the gaps in the system and the ways in which that the system fails journalists. I want to now invite all of your comments on what it is we can do to reimagine the justice system for journalists. So again, my first round of questions is for Ms. Seema Chishti. Last November, we read in newspapers that the state of Chhattisgarh was considering enacting a law for the protection of journalists from harassment and intimidation. So I wanted to ask you what in your view would be press safeguards that would be essential in a republic, not just to prevent self-censorship, but also to protect journalists' lives and liberties, their sources. And is it something that we'll need to enact into a new law, or are these safeguards that we can somehow work into being in the present legal system as it stands? Maybe we've just not used them correctly or innovatively. So I want to invite your comments on this aspect, ma'am.
Yeah. Malvika, I think that, I'm a little wary of wanting to always enact new laws, because that's like a very easy, it's no silver bullet. As we've known, we probably have the best compendium of laws to assist journalists and all of that. The point is how we interpret them and we use them. And I completely agree with what Justice Lokur said, that it's the judiciary, it's the onerous responsibility of the judiciary to back the journalist, or I mean, as is very well put out by both Colin and Justice Lokur, that it's not just journalists, it's about anybody asking questions or not being on the side of power, as it were, that it's the last person on the block, as it were. So I think we need spine, we need a good attitude. We need to kind of almost refresh the way we look at our democracy and to recognize the role of independent media, to kind of do away with these words of are you national or anti-national, to take that seriously, to actually ask questions, to enable the asking of questions, and to almost kind of lose this fear of Voldemort. You know, you need to kind of get away from that. So I think it is much more of an attitudinal shift we need, and refresh our democratic practices vis-a-vis journalists. Because I think the judiciary, and I'm not laying too much by its door, it actually stands at what allows for the collapse of a democratic system, and not, because it's the last it's the last person standing who has to actually decide and tell you things. Of course, the government would put pressure, the mobs and the public would behave in a particular way. Well, what stands between a fair democracy, a liberal, healthy democracy, is judiciary. So I think how we do these laws is important. So that said, I think journalists need to be judges need to be sensitized, and I like the fact that judges give these very good speeches, etc., when they are addressing special moments and days. But if that same element can be brought in when they are on the bench and doing that, we'd be much more empowered for it. Then I think it's also kind of other press institutions. So you have the Press Council, you have the National Broadcasters Association, you have the Editors Guild. I think even journalists need to kind of get our act together. So far, what's been happening is that it becomes kind of a piecemeal thing, depending on if you like a particular journalist who's being harassed or not being harassed. It becomes kind of organizing around a particular case. But I think we have to understand that it's pretty much for whom the bell's toll, that it's the Pastor Niemoller principle, that, if you're going to allow the principle to go away, it's going to come and get you very soon. So I think a lot needs to be said about how journalists also are organizing themselves, and they need to question the criminal defamation issues. They need to go into sedition and ask clearly about the difference between, we need to do what our freedom fighters did, when the sedition was enacted. We need to do what Gandhi did. And it's a tragedy that we're saying all this like in a new millennium, but we need to actually go back and ask those questions. So a lot is on the journalists also to demand their rights, to be able to, and to not self-censor, because you can never appease the beast. So self-censorship is not going to help. And the third, of course, is the environment of the people. So I don't know what we can do by way of actually raising the awareness about what a free press actually means, because if we lose public opinion, and public opinion thinks that journalism is only about kind of cozying up to people in power and of earning a salary and of just saying the right things, or just just being his master's voice kind of thing, that's not going to help us either. So we need to get people on side. So may I kind of, even at the risk of sounding over the top, if a free press dies, democracy will not survive. And without this kind of democracy, I don't think India stands a chance. So we're actually at a very, very serious point of which way our democracy will go.
Thank you, ma'am. Mr. Gonzalez, again, on the theme of how we can improve the system to answer the concerns that the press community faces today, I want to invite your comments on the model of protection that the state of Chhattisgarh has proposed, and also just a broader set of comments on what would be an appropriate process that law enforcement and police ought to follow while registering these FIRs, accepting these accusations? Or is there something larger and systemic that we need to do? Do we need to invest in training investigative authorities to distinguish fact-based from opinion-based reportage? Do we need to invest in training them to distinguish hate and panic mongering from just speaking truth to power? Where do you see that we need to put in the work to rework the system to make it safe for the fourth estate?
Well, I'm not a great fan of training the police to, learn the law and so on. And I have, over the years of my practice in Delhi, I came to Delhi from the Bombay High Court in the year 2000. And Delhi is a very interesting place because you see stark power play. Bombay is still a little far away from the manipulation of policemen and so on. But in Delhi, you see it in a very stark way. And I've come to the conclusion, and people have scolded me very often for saying this, and I think I'll get scolded again. I really believe, because I've seen it in the countryside, I've seen it in rural areas, I've seen it, right across the country, because I travel quite a lot. I have a network of lawyers, so I travel quite a lot. I believe the police is today the largest body of organized crime in this country. They engage in criminality at such a level and at such a expansive, spread, that it is very difficult for you to really train them. We've done trainings and they take trainings as if it's a joke. I would say we try and rely upon our own strength. First, despite the depletion of our forces and our strength during COVID, despite the numerous attacks on journalists, the journalists are still a very powerful body in India. I know from my point of view of practice and, working within the judiciary, judges are very conscious of what is being said about them, their judgments, their approach to social issues. You are a very powerful body. But I think Seema said we must put our act together. You all are very litigation averse. When things happen around you, which are so terrible, I mean, just look at the sedition cases, and I gave you Kishore Chandra's case and so on. You all are not raising the ante to such a level that you take it as a collective insult. It becomes the individual problem of an individual journalist. It's like Seema Mustafa, who's been taken for writing about Gujarat industries and so on. He has to, face the consequences and defamation. So it requires collectivization. It requires mobilization. It requires a strong element of a trade union approach, that we'll mobilize, we'll organize, we'll come out on the streets. And an insult to any journalist, harm caused to any journalist, is a harm to us all. So we have to raise the level of the work. And what I have been advocating for quite some time is that you build a network of lawyers and journalists and judges. Build a network right across the country. Set up a core monitoring unit. Now we published a book on all the attacks that have taken place. There are journalists in Mumbai who are also monitoring every single attack that takes place in the country. But that's monitoring. Crisis response to journalists is very little and is very poor. So you need to get the journalists and the lawyers and the judges and the academics and students together to form a powerful organization, to look after each person. I remember we did a national convention in Delhi 6 years ago, where 100 journalists from all across the country came, complaining of defamation, complaining of victimization, complaining of, illegitimate transfers, termination of services, physical attacks. And what struck me most in that conversation was journalists from remote areas saying, we felt so alone in our struggle. We stood up for democratic rights. We stood up for human rights. We wrote articles. But when it came to the attack on journalists, we felt so alone and isolated. And that's what we need to do. We need to use the existing law. That's again another lesson. Whenever there's a crisis, we say, let's make a new law. But making a new law is not the solution. Making a law in today's circumstance with the central government being what it is, or the central government could twist the best draft that you could possibly give them and come out with the most draconian legislation. So I wouldn't trust this government at all in terms of making law. Use the existing law. It's pretty good. It's pretty powerful. And if you fan out to all the high courts of the states, connect with lawyers in every state, and have a journalist-lawyer combination right across the country, which is not just relying on the law, it's using the law, but it's also agitating and mobilizing and supporting journalists when they are down. I think you would get quite a few results right across the country. Now take COVID. During the period of COVID, government attacked the press terribly, right? Layoffs, closures, lockouts, half salary, quarter salary. Can you imagine? And if you look at any one of those actions, it's completely contrary to industrial labor law, completely contrary. And the Working Journalists Act treats you like a workman. How do you close a part of an establishment which has more than 100 employees? How have they done it right across the country? How do they retrench employees that have more than 100 employees? Because you have to take permission from the state government if you retrench in any establishment having more than 100 workers. And a journalist is a workman. When you close or you partially close a department, you've got to take permission. He's ready to go to court. And everyone's scared, and it's every person for himself kind of mentality, which is understandable. That, hey, I don't want to fight. I don't know how long I can fight. I can't sustain. That is like the earlier years of the trade union movement. Every person for himself. That's the best way forward. Let's not bother about my colleagues who are in the same situation. All of us crying. But let's look after myself. And that's overcome now in the trade union movement. We fight together. So in the journalist movement as well, and you have some fine journalist unions, it's very possible. And I don't think it will take very long because the suffering of journalists today is terrible. It has never been so high. Journalists have never felt so badly treated, so treated with indignity, roughly treated as they are treated today. And I think it will not take long for journalists to get together and form a powerful national union which spreads across the country and fights for the rights of people. Take the Majitya Committee report, one of the finest wage board reports in the country, recently made, right? Taking journalist salaries up double, making contractual journalists on par with wage board journalists. Can you imagine? What a brilliant wage board award. And zero implementation. Because there's just no union in this country ready to implement one of the finest wage boards. From Bachawat and all that, today you have the finest wage board and nobody is ready to fight. So I think some of our people, and we have so many, such a pool, such a depth and expansive pool of talent, of resistance, of rebellion, of anger among journalists. I think the time has really come. Use the legal system expansively, not in the petty way we've done so far, in the small, minuscule way in which we've done it, but use the legal system, right? Mobilize judges and students and academics, to speak for freedom of speech and expression and the rights of journalists, and form a union. Now's the time.
On the note of COVID, I'm going to invite Justice Lokur's thoughts on how the criminal justice system can respond better. And I do not mean to underplay the dangers of COVID, either to the magistrates who are unable to serve the criminal justice system in the way that they ought to, but just to speak to the kinds of complications that COVID has raised. So even in big metros where we have good internet connectivity, there has been a great degree of ambiguity on what's an urgent matter. Of course, some high courts have come out and clarified the meaning of urgent. They've clarified that bail applications should be treated as urgent. Then there was a certain amount of uncertainty on whether production before the magistrate of the accused should happen in person, given the danger of COVID. VC options are not uniformly available across the state, particularly outside large metros, and even the production of an accused through virtual conferencing is not the most ideal way to ensure that the accused is being treated well in police custody. And so that kind of defies the principle itself of magisterial production. So there have been a range of complications that have arisen in the period of the pandemic as the criminal justice system has tried to serve its purpose. And of course, I don't know of any instances where journalists have been produced before the magistrate in the last 2 months. But so I just wanted to invite your comments on what we can do better. Is there some way we can innovate with the Legal Services Authority? I know you've spent long years thinking about that question. So what is it that during the pandemic we can be doing better to enable the access to criminal justice for journalists and others who are confronted with the system?
Yeah, thank you, Malvika. This definition of what is an urgent matter, kind of surprises me, in the sense that what is an urgent matter has been known for a very, very long time. Courts are closed in the summer vacation, right? But there are vacation judges or vacation benches, and they take up what is called an urgent matter. That's why they're there, right? So what is the meaning of an urgent matter is something that has been known for I don't know how many years. The arrest or the bail, bailing out of a person is an urgent matter. Should a person be remanded into judicial custody or police custody is an urgent matter. Should the person be given bail or should not be given bail? Should the person be given anticipatory bail or should not be given anticipatory bail is an urgent matter. The demolition of a house is an urgent matter, right? You can't demolish a house and say, well, there's nothing urgent about it. So what if your house gets demolished? Okay. So you have a large category of cases, not a very large category, but you have a category of cases which by definition are urgent. Your landlord wants to chuck you out of the house. There's a decree for eviction. So next day you'll find yourself on the road. That's an urgent matter. So really this thing about what is urgent and what is not urgent, I think is completely misplaced. Now, for some courts, therefore, to say that, well, bail matters are not urgent, I think to me, it just defies logic. Personal liberty is always urgent, right? So if a person applies for bail, it's an urgent matter. The court must hear it. It can't say, I'll take it up after, a couple of weeks. You hang around in jail until then. That's not correct. So really this thing, about during the time of this pandemic, whether bail is urgent or not urgent, I think is a complete, red herring, so to speak. Bail is definitely urgent. Now, what about the production of a person? The Karnataka High Court has taken the view that the production of a person for the first time that the person is produced before the court should be physical, right? It should not be virtual production. I think that's good. It should be followed, definitely. But the magistrate must realize the importance of this. Again, going back to that, what happened in Tamil Nadu, these persons were produced before the magistrate, right? But the magistrate didn't look at them. So what is the point of that physical production? It makes no sense at all. So really, this thing has to be taken very seriously. That when a person is accused of an offense, whether it is pandemic or whether it is not pandemic, the magistrate has a very important role. Okay, now you could have, you have video conferencing in jails. It's been going on for a long time, where persons who are in jail are produced, virtually. It's not something which just happened during the pandemic. It's been going on for the last 10, 15 years. Now, there are, protocols that have to be followed. The magistrate has got not one camera, but he could have maybe 2 or 3 cameras. He can tell the person over there that, listen, I'd like to see the back of this person, right? If that person says that I was beaten up, magistrate can say, yeah, well, I'd like to have a look at his leg. to see whether he was beaten up and there are bruises on the leg or on the back or wherever. Legal aid becomes very important at that point of time. The legal services authority have a very, very important role to play. It's not that some legal aid lawyer is standing over there, so the magistrate says, all right, you represent him. He doesn't know anything about the case. What representation is he going to give? So the legal aid lawyers, the legal aid authorities, whether it's the State Legal Services Committee or the National Legal Services Authority or at the district level, they have to take their task very seriously and be in touch with the person accused of an offense. Now, you've had instances in Delhi. Recently, it's been coming in the newspapers where one of these ladies who's been arrested as an under trial, she's not able to communicate with her family. She's not able to communicate with a lawyer. And today it came out that, well, if the lawyer comes, then the person from the jail staff or whoever it is within hearing distance. That's not permitted. So what happens to social distancing, by the way, in a situation like that? It's just completely tossed out of the window. So really, it's not that the law changes just because there is a pandemic. The law remains the same. You still have to follow certain protocols. You still have to follow certain procedures. Habeas corpus, Seema was mentioning 99% or something, she said, have not been taken up. Why? Personal liberty is not important. It's not urgent. How can anybody say that? So really, these are issues, whether they pertain to journalists, like you said, perhaps no journalist has been produced before a magistrate so far. But whether it pertains to a journalist or whether it pertains to an individual, there is a very important role that the magistrate has to play. There is a very important role that the legal services authorities have to play. There's a very important role that the police have to play. You can just, I think you had probably mentioned about, fact-based news. Now, something is a fact. It may later on turn out to be incorrect. There may be a good reason to say that, well, this fact was not correctly presented, but it's a fact. You can't say that because you've reported a fact, therefore it is sedition. Fake news can always be tackled. I mean, there is enough, government machinery to tackle fake news. Don't tell me that, if somebody spreads fake news, nothing can be done about it. Of course, something can be done about it. So really, these are things I think everybody has to be a little careful. And like Colin said, perhaps the journalists will need to think, about moving forward. A statement given by some association of journalists or something, it comes out in the newspapers. What happens to it? Perhaps get chucked into a waste paper basket. That's it. So really, I think the journalists will have to be far more active than they are at the moment. Legal recourse is certainly available. Thank you.
Thank you, sir. I think I'll proceed to audience Q&A in the next few minutes that we have. There have been a range of interesting questions. I've just sorted through some of them. The others have been answered over the course of our conversation. So Ubaid asks of the panel generally, he asks, what is your view on institutional attack on citizen journalism, particularly here in Kashmir? Of all the things that we have to deal with during the COVID outbreak, the administration has said that doctors who post on the internet about the lack of medical infrastructure and administrative indifference will be dealt with and may even lose their jobs. So what can we do about citizen journalism is Ubaid's question in the particular context of Kashmir.
Yeah, can I take that?
Of course, sir.
Yeah, okay. This is that fact-based thing that you were talking about.
Yeah.
If it's a fact, maybe an uncomfortable fact, why should it not be reported? The purpose of this is to improve things, So if the hospitals are not doing their job properly, or the doctors are not doing their job properly, or health workers are not doing their job properly, whoever, whether it's Kashmir or wherever. And it is pointed out that, listen, you guys are not doing your job properly. What's wrong with it? If it's factually correct, there's room for improvement. And that's what that citizen journalist or any other journalist is trying to achieve. And improvement in the situation and improvement in governance. So I don't know how anybody can say that, you're going to lose your job because you're speaking the truth. What's wrong in speaking the truth, even if it's uncomfortable?
I suppose the question, sir, would be at what point can we introduce that filter that checks for fact-based as opposed to opinion-based reportage? And I wonder if you'd like to share a comment on that. Where in the stage of investigation should that kind of filter be introduced?
Yeah, well, that's a part of investigation, actually. That's what the police has to find out. That is this person reporting a fact or not? And just because a person is reporting a fact and somebody is uncomfortable with it, you can't say sedition, sovereignty and so on. It can't be like that. Then what is press freedom all about? Might as well say that, listen, there's no press freedom. Let's be candid about it. You can't report the truth.
There's a related question again to everyone on the panel. A sense of alarm appears to exist among the common people. This is by Advocate Feroz A. Sheikh. His question is that UAPA, NSA, and sedition law have really scared people into not speaking up. So how can we, I suppose his question is directed at Ms. Chishti, who had earlier said, public opinion has turned against journalists. So what is it that the common man can do in this context when the UAPA, NSA, and sedition law can be weaponized against us?
Yeah, that's a trick question, because to urge the common man to stand alone as he has all these draconian measures. So I think here the people who are more powerful, who have a more voice, need to stand up. And so that, these things are infectious. That
is Ms. Chishti on the line? Or?
Hi, Malvika, I think we lost ma'am. I think we can take the next question. Once ma'am joins back, we will have this. Yeah.
Okay, perfect. Okay. The next question is for Justice Lokur by Ishan Mata. He asks that although FIRs may be quashed by courts and the accused may ultimately be acquitted, the process in itself becomes the punishment and has a chilling effect on journalists.
Right.
So the question, sir, to you is, can courts take penal action against the concerned police officers for lodging these plainly frivolous and vexatious FIRs?
They can and they should. That's the only way to check it. Yeah, they can. And according to me, they should. Why not? Just because he's a policeman doesn't mean he can do whatever he likes. He has to be fair. After all, that person is also a citizen of India. So yes, certainly. I would say yes.
So there's one more question on similar lines to you, which is, and I suppose Dr. Gonzalez might also have some thoughts on this. Aditya Rumta asks that if the judiciary is to be vigilant, how can we ensure accountability when the judiciary fails? For example, in Tamil Nadu, where the magistrate reportedly did not see the accused in person. Should the police officers have been, if the police officer should have been suspended, then what action and accountability could we have fixed on the magistrate?
Yeah, Colin, go ahead.
Yes. Yes, sir. Well, I was thinking as the question was being asked, it's actually not just that the magistrate should be vigilant. I'd like to go a few steps behind and say all of us need to be vigilant. every one of us. And the time has come when we should not rely. Yes, we go to the court. Yes, we hope judges will support us. Yes, we hope that fine judgments will be made. But don't expect it as a guarantee. It may happen, it may not happen. And in today's time, when judges have to some extent surrendered their independence from the executive, and judges have to some extent, and not all of them, but some of them, have actually come very close to the executive, right? You must be vigilant. It's important for citizens to be vigilant. It's important for citizens to be willing to fight the next stage. If the magistrate doesn't give you the order, the High Court may. If the High Court doesn't, the division bench of the High Court may. If they don't, it's the Supreme Court may. And never give up. Be resolute, never give up. And don't repose the power that you have in yourself, in your being, in your spiritual being, in the absolute. Don't put that in somebody else and say, I hope A does it, and B does it, and C does it. Because this is a period of abdication of responsibility. Take the NHRC. It's been such an inert institution. It's supposed to protect human rights. And yet for the last 10 years, it's been a complete washout, right? So never say A will do it, B will do it, C will do it. Come forward yourself. Don't look behind you and say, is anyone supporting me? I will only act if I have 10 or 20 people around me. Don't be like that. Come forward, set an example, be an inspiration to young people all around you. And you will find the magic of India in that. And the magic of India is that when everybody feels, oh, everything is lost, you will find people mobilize and galvanize and stand up for rights. Even at great personal loss, you will find you will inspire people to do things which they thought they were incapable of. And that's the situation today in our country with this government and what they're doing to people and what they're doing to journalists and others. That's the situation. And today we have to all come forward. Millions of Indians, young Indians, come forward and set an example. And you will find the country will follow you. I have that confidence, that 100% confidence, no doubt at all that the young will follow you. Set an example of resistance. Set an example of opposition to tyranny, and the young will follow you.
Justice Lokur, would you like to also come in on that question?
Yeah, well, I agree with Colin that everyone has to be vigilant, and that includes the press, because the press can disseminate that information. That this is what has happened, this is how the magistrate in this particular case has acted, and which has unfortunately resulted in the death of these two persons. But, the thing is, Colin is right that if you don't succeed before the magistrate, go to a higher court and so on. But like I said in my opening remarks, how many people can afford to come to the Supreme Court? That is the question. That's where I think legal aid has to be far more, stronger, vigilant, active. Otherwise you have so many people who are lying in jail. They're not able to come to the Supreme Court. Supreme Court has said that, you release people on parole during this COVID pandemic. So many people are still there. They're not getting bail. Why? So, they can't come, somebody can't come and say that, listen, you have passed this order, but it's not being implemented. So therefore, why don't you grant me bail? It's not easy. So I think the whole system has to be strengthened, and the press can play a huge role in this. Let me tell you, huge role.
I think Ms. Chishti is back on the call. So should we circle back to the question on the weaponizing of the UAPA and the NSA against the common public?
Yeah. Yes. Just two broad points, which kind of, what I was saying was that courage is often very infectious. So kind of picking up from what Colin said and Justice Lokur said, that citizens cannot kind of also abdicate this thing. I cannot outsource this job to somebody else, to political parties, to even the NHRC. We've seen what they've said in the context of students in Jamia, for instance. So I think all of us have to do our job. And in that sense, we are kind of luckier than what, say, freedom, the people in the freedom movement were, because, they were in the business of making this, the Constitution for us. We have an excellent book by which, so we just literally have to just play by the book and assert our rights, because as much of space as would be conceded, bullies, whether they are people in government, whether they are police people, or whether it's even your next door neighbor, is going to trample on your space. That must be understood, and try and generate as wide a virtuous circle of courage as we can. Only something which maybe citizens should understand and realize, that if they're coming if they're going after journalists, these are all signals. These are sophisticated signals that parties in power with a majority, with which are confident governments who want more control do. That it's an example that if you can do it to this journalist, or this kind of this voice of a certain thing that he's been saying robustly for decades now, if I can catch him under sedition, think of what's going to happen to you. So this is not, so the one way could be that everybody gets paranoid. But I think to just understand that that's the message being given down, and that message is not acceptable. So I think citizens will also have to start doing their bits and not kind of outsource it to their favorite, anchor, or their favorite journalist, or their favorite lawyer, or favorite judge. So I think this will have to be fought as citizens, and our Constitution gives us the right to do that.
So one more question on similar lines to you, Ms. Chishti. Michael, I'm combining the questions, taking the liberty to combine the questions of Michael, Rupali, and one other person. And the questions are, how can journalists work with institutional constraints in their organizations who are just trying to look after their families? Is there some support that they can get from editors' guilds? If so, what? And what particularly can be done about the press card issue for freelance journalists? Yeah, that covers all of them.
Okay, so as far as getting support from institutions like Editors Guild, etc., quite frankly, I think that will be quite outside the remit of what Editors Guild does or is doing. So I'm sorry, at the moment, it's pretty much of a, you're on your own. It's a solo thing of journalists really negotiating in very difficult circumstances within their particular organizations. So one would just say that be smart and speak as much of the truth as you can while being mindful of your other responsibilities, economic or otherwise. So, just be as sagacious and smart as possible. And if possible, unionize or collectivize in some ways that you can make your management staff, seniors, editors feel more responsible and take more responsibility. On the other question, I think that's a very important question that needs to be raised with the Press Information Bureau, because there are also, for example, websites. There was a time when websites were not, and I think they still aren't given accreditation, and they don't have access to covering Parliament, etc. I think for that, a long battle has to be fought. And I think journalists need to get together. And that's where I think journalistic bodies come into play. So maybe the National Broadcasters Association, the Editors Guild, the Press Council can be lobbied and spoken to and told about having yardsticks by measuring what journalistic activity is, and asking why they cannot be accredited. But I'd also say that accreditation also at a point is a bit overrated thing. There are some really fine journalists who've done extensive, good work, and they are not accredited or authorized to do that work. So I think they must also kind of push the envelope a little bit, inch by inch, and things clear. But yes, attempts must be made through these organizations to lobby and get the more prominent, award-winning freelance journalists, the seniors on the job, to get together and make this case. That we must do.
We have one last question, and this one I think is timeless. For as long as the Republic has existed, we have asked this question, and I will invite Dr. Gonzalez's comments on it. This is from Saad. In a free society, how can we make space for radical or dangerous speech? How can we draw a line between free speech and hate speech? and what metrics can exist for determining what constitutes hate, because hate can be subjective. And I know this is a question that has no answers, but it's an important question nonetheless, because we've seen some kinds of arguably hate-mongering speech be condoned and other kinds of quite innocuous speech come within the net of those provisions. So, so your comments on
well,
that.
let me take a little liberty with the question. And it might be a very good question on which to maybe take this conversation to its gradual end. And I want to argue, and I want to say this first. We must recognize we are coming to a fundamentally different epoch. It's going to be a fundamentally different world. And people are going to play a fundamentally different role. We perhaps can't even imagine what is going to happen in the years to come. But we know one thing, that with the levels of desperation existing in society and people being treated with such indignity, this is not going to last for long. We will go through a period akin to the national movement. It will be like a second national movement. It will be like a liberation, and a liberation where the young and the students will play a very important role. Because India has one of the largest numbers of young people. If you look at all societies, all countries across the world, we have the largest numbers of young people. The old is going, the young is coming, and we are caught in that interregnum between the old and the young. What should a judge do? Should a judge sit behind his table and, make orders? I saw Justice Krishna Iyer in Kerala when there was an eviction of people in the marketplace. He put a crate. He stood on top of that crate and he lectured on the Constitution and human rights and resistance for 45 minutes and inspired people to protest. I went with Justice Suresh for so many fact findings right across the country. Retired judge. What should a retired judge do? He should sit at home and read the newspapers and talk to his friends. He went for 100 fact findings across the country, and he went to Manipur and he fought against the Armed Forces Special Powers, the misuse of the Armed Forces Special Powers Act in Manipur. And today the killings have come down from 300 a year to 3. What I'm trying to say is, students, what should a student do? Should a student study? Should he listen to what his professor says? You must study. You mustn't get involved in politics. Nothing doing. Students are leading the new world change. Students are studying. They're getting excellent grades. They're very good at their work, but they are agitating and struggling and striking and mobilizing and traveling across the country and not listening to the kind of nonsense we hear from our political leaders and everybody. There are no leaders, and the young are going to lead. So if you ask, what should we do? We should prepare for a revolution in this country. It is going to happen. People will laugh at you because they say, oh, well, it has to happen. With millions of people without food, without employment, without a place to stay, beaten by the police. What will happen? You must anticipate a new world. And as journalists, it's not just your duty to write good articles. Because you write a good article and you write things of value to society, your services will be terminated, your department will be closed down, and you will have an editor who's such a lackey of the government that he will stop you from writing. So journalists will have to innovate and do different things, but journalists will also have to agitate. You will have to build organizations. Take the example of students. Look at the students of Aligarh. Look at the students of Jamia. Look at the students of JNU. Look at the students in Dalit universities across the country. They are leading a new world. And you journalists are a very important part of that. And you must organize, mobilize, agitate, educate. And that is the new world we'll move to. And it's not just a dream. It's going to happen. And not very far away. It's going to happen quite soon.
It's a bit of a catch-22 for journalists who are under this much pressure. Do your jobs, come under pressure. to do your jobs.
But everyone's under
on
pressure.
that's right, sir. That's right. On that note, I just want to say that to me, at least, this was an incredible, insightful, and learning opportunity. As a young lawyer, and I think I speak for all of the young bar that has tuned in today, our roles to facilitate these kinds of claims that journalists may make of the court has really been thrown into sharp relief. So while journalists may have to organize, I think lawyers have to also do some of the hard, heavy lifting, and of course, courts have their part to play. So thank you everyone for joining us. Thank you to this amazing panel for giving us your time this evening. It, as I mentioned, was an excellent learning opportunity. And before I close, I just want to share with everyone who's streaming this discussion today that the next webinar that LiveLaw will be hosting will be on the 3rd of July, that is Friday, at 5:30 p.m. And it will be on custodial debts and the need for an anti-torture law, which I think, again, extremely important and timely conversation given the news about Jairaj and Phoenix in Tamil Nadu. So please do tune in, 5:30 on Friday, 3rd July. Thank you very much.
Thank you.
Thank you. Thank you.
Thanks a lot. Thank you.
Thank you, Seema. Thank you, Colin.
Thank you. Thank you, sir. Thank you. Thank you, Colin. Thank you, Malvika. Bye-bye.
Bye.